Hello students, your topic for today is registration of trade unions. So, the main object of the Trade Union Act 1926 is to provide machinery for registration and regulation of trade unions. Although registration of a trade union is not mandatory, it is advisable to register the trade union, as the registered trade union are entitled to get several benefits, immunities, and protection under the Act. There are specific rights and privileges that are conferred on the members of the registered trade unions. The members of the registered trade unions are entitled to get protection, immunity, and certain exceptions from some civil and criminal liabilities. A trade union can only be registered under the Trade Union Act 1926 and cannot be registered under any other act, including the Societies Registration Act or the Cooperative Societies Act of the Indian Companies Act. A civil servant union cannot be registered under the Trade Union Act 1926. Then there are certain cases, like in the case of Tamil Nadu NGO Union versus the Registrar of Trade Union, the Madras High Court dismissed the appeal on the ground that to get the trade union registered under the Trade Union Act 1926, the member of the union must be workmen engaged in trade, business, or industry, and the appellants in this case are not in that capacity, as they are civil servants engaged in the task of a sovereign government. In case of registration of trade unions, West Bengal versus Mihir Kumar Ghochu, the Calcutta High Court held that employees of ESI Corporation would come within the meaning of the workmen, and hence they could be registered under the Trade Unions Act. Chapter 2, containing section 3 to 14 of the Trade Union Act 1926 and Central Trade Union Regulation 1938, containing 17 rules and forms ABC, provide for the procedure and formalities for registration of the trade unions. For registration of the trade union, an application shall be submitted to the Registrar of Trade Unions appointed by the appropriate government under Section 3 of the Trade Union Act 1926. So, Section 4 provides for the mode of registration. According to Section 13 of the Act, every registered trade union shall be a body corporate by the name under which it is registered. Such registered trade union will have perpetual succession and a common seal. A registered trade union can sue in its own name and can acquire movable and immovable properties in its own name. Now, the legal status of registered trade union. So, upon the registration, a trade union assumes to a corporate body by the name under which it is registered. A registered trade union shall have perpetual succession and its common seal. A registered trade union is an entity that is distinct from the members of which the trade union is composed of. It enjoys power to contract and to hold property, both movable and immovable, and to sue and be sued by the name in which it is registered. A trade union that has been registered in a body corporate which has a common seal and a perpetual succession, it can hold, sell, acquire, or transfer any property that is maybe movable or immovable and can also be a party to the contract. It can be sued and can also be sued in its own name. Also, no civil suit or any other legal proceedings can be brought against a registered trade union in respect of any act done in the furtherance of trade dispute under certain circumstances. An agreement that is between the members of a trade union that has been registered shall not be voidable or void merely on the ground that the agreement or its objects is in restraint of trade. Chapter 2 of Trade Unions Act 1926 deals with the provision of the registration of trade union, and according to section 2 subsection H of the Act, trade union means any combination, whether temporary or permanent, formed primarily for the purpose of regulating the relations between the workmen and employers, or between the workmen and workmen, or between the employers and the employers, or for imposing restrictive conditions on the conduct of any trade or business, and it includes any federation of two or more trade unions. Thus, the present article shall deal with the most important aspect of union, and that is the registration of trade unions. Appointment of a registrar. So, according to section 3 of the Act, the appropriate government has to appoint a person to be the registrar of trade unions for each state, and the appropriate government shall also appoint as many additional registrars as it may deem fit to carry out the purpose of the Act. Below is the section 3, that is the appointment of registered registrars stated, that states, and the appropriate government shall appoint a person to be the registrar of the trade unions for each state. Subsection 2, the appropriate government may appoint as many additional and deputy registrars of the trade union as it thinks fit for the purpose of exercising and discharging under the superintendence and direction of the registrar, and such powers and functions of the registrars under this act as it may by order specify and define the local limits within which any such additional or deputy registrar shall exercise and discharge the powers and functions so specified. Subsection 3, subject to the provisions of any order under subsection 2, where an additional or deputy registrar exercises and discharges the powers and functions of the registrar in an area within which the registrar office of a trade union is situated, the additional or the deputy registrar shall be deemed to be the registrar in relation to the trade union for the purpose of this act. Mode of registration. So section 4 deals with the mode of registration. It This section in the act provides for the mode of registration of trade union. According to this section, any 7 or more than 7 members of a trade union may by application apply for the registration of the trade union subject to the following two conditions. The first condition is at least 7 members should be employed in the establishment on the date of the making of the application. The second condition, at least 10% or 100 members, whichever is less, are employed in the establishment should be a part of it on the date of making the application. Also, such application shall not be deemed to be invalid merely on the ground that at any time after the date of the application but before the registration of the trade union, some of the members, but not exceeding half of the total numbers of persons who made the application, has ceased to be members. Now, application for the registration. So, according to section 5 of the Act, every application for the registration of the trade union shall be made to the registrar and shall be accompanied by a copy of the rules of the trade union and a statement of the following particulars, namely: first, the names, occupation, and addresses of the members making the application; second, the name of the trade union and the addresses of its head office; and third, the titles, names, ages, addresses, and occupations of the office bearers of the trade union. Now, where a trade union has been into existence for more than a year, then a copy of the assets and liabilities shall also be submitted along with the application for registration. Now, provisions to be contained in the rules of a trade union. According to section 6 of the Act, a trade union shall not be entitled to registration under the Act unless the executive committee has been established in accordance with the provisions of the Act, and the rules provide for the following: first, name of the trade union; second, whole of the objects for which the trade union has been established; third, the whole of the purpose for which the general funds of the trade union shall be applicable; fourth, the maintenance of a list of the members of the trade union; Fifth, the admission of an ordinary member who shall be persons actually engaged or employed in an industry with which the trade union is connected. The conditions under which any member shall be entitled to any benefit assured by the rules and under which any fine or forfeiture may be imposed on the members. Next is the manner in which the rules shall be amended, varied, or resented. Then the manner in which the members of the executive and the other office bearers of the trade union shall be elected and removed. After that, the safe custody of the funds of the trade union, an annual audit in such manner as may be prescribed of the accounts thereof, and adequate facilities for inspection of the account books by the office bearers and the members of the trade union, and last, the manner in which the trade union may be dissolved. Now, the power to call for further particulars and to require alteration of name. So, according to Section 7 of the Act, the registrar may call for further information for the purpose of satisfying himself that whether all the particulars are in accordance with Section 5 and Section 6 of the Act. So, in the case of the trade union applying for registration bears a name identical to that of an existing trade union, and the registrar feels that the name so resembles that of the other that there are fair chances of the person being misled, then the registrar shall ask the trade union applying to change the name and shall refuse to register the same until such alteration has been made. Rights and duties of a registrar. So, Section 7 of the Act empowers the Registrar of Trade Union to make, if required so, further inquiries on receipt of an application for registration to fully satisfy himself that the application complies with the provisions of Section 5. However, such inquiries can be made only from the application and not from any other source. So, the duties of a registrar of trade union in matters of registration of trade union are laid down under Section 8 of the Act. On having been satisfied with the requirements for the registration of the union, the registrar shall register the trade union by entering in a register. The letter to this effect will be issued to the trade union. In case of a non satisfaction of registrar with the compliance of requirements, the refusal for the registration will be issued to the trade union. No time limit for the grant or refusal of registration has been prescribed in the Trade Union Act 1926. However, there are legal directives issued by the court to the Registrar of Trade Union to perform statutory duty imposed upon under section 7 and 8 to deal with the application of the trade union according to the law at an early date. The National Commission on Labor has suggested 30 days excluding the time which the union takes in answering queries from the registrar for the grant of refusal of registration by the registrar. The Trade Unions Bill 1982 has provided for insertion of the words within a period of 60 days from the date of such compliance. After the words register, the trade unions in Section 8 of the Trade Unions Act 1926, where, however, registrar refuses to grant registration to trade union, he is under an obligation to state reasons for refusing to grant registration. The Societies of Registration Act 1860, Cooperative Societies Act 1912, and the Companies Act 1956 do not apply to trade unions, and registration thereof under any of these acts is void ab initio. Now, according to Section 8 of the Act, if Registrar thinks that the trade union has complied with all the provisions of the Act, it shall register the trade union by entering in a register all the particulars in accordance with the provisions of the Act. According to Section 9 of the Act, the Registrar has to issue the certificate of registration to the trade union after registration under Section 8, which shall be conclusive proof that a trade union has been duly registered. Now, cancellation of registration. So, Section 10 of the Act A certificate of registration of a trade union may be cancelled or withdrawn, or an application of the trade union to be verified in such manner as may be prescribed, where the registrar is satisfied that the certificate has been obtained by fraud or by mistake, or the trade union has ceased to exist, or has wilfully and other notice from the registrar contravened any provisions of the act, and if the registrar is satisfied that the registered trade union ceases to have requisite number of members. So, a certificate of registration of trade union may be withdrawn or cancelled by the registrar on the application of the trade union to be verified in such manner as may be prescribed in if the registrar is satisfied that the certificate has been obtained by fraud or mistake, or that the trade union has ceased to exist. It has to be provided that not less than 2 months previous notice in writing specifying the ground on which it is proposed to withdraw or cancel the certificate shall be given by the registrar to the trade union before the certificate is withdrawn or cancelled otherwise than on the application of the trade union. In the case of Solapur District Central Cooperative Bank Employee Union Solapur, the registrar cancelled the registration of the union after single show cause notice of 2 months. The Mumbai High Court held that generally a second show cause notice is required to be issued. However, it further held that where the contravention is of overset kind, one single notice of 2 months may be sufficient. Hence, the cancellation of registration was valid. Now, change of name. So, section 23 deals with the change of name. Any registered trade union may, with the consent of not less than two-thirds of the total number of members and subject to the provisions of section 5, change its name. So, section 23 is basically stating that any registered union is free to change its name provided it does so with the consent of not less than two-thirds of its members and subject to the fulfillment of the conditions that are laid down in section 25 of the act. Now, section 25 is talking about the notice of change of name or amalgamation. So, first is that the notice in writing of every change of name and of every amalgamation is signed in case of a change of name by the secretary and by 7 members of the trade union changing its name, and in case of an amalgamation it should be signed by the secretary and by the 7 members of each and every trade union which is a party thereto, shall be sent, and this should be sent to the registrar where the head office of the amalgamated trade union is situated in a different state, to the registrar of such state. Subsection 2. If the proposed name is identical with that by which any other existing trade union has been registered, or in the opinion of the registrar so nearly resembles such name as to be likely to deceive the public or the members of either trade union, the registrar can refuse to register the change of name. Subsection 3. Save as provided in subsection 2, the registrar shall, if he is satisfied that the provisions of this act is in respect of change of name have been complied with, register the change of name in the register referred to in section 8, and the change of name shall have effect from the date of such registration. Subsection 4. The registrar of the state in which the head office of the amalgamated trade union is situated shall, if he is satisfied that the provisions of this act in respect of the amalgamation have been complied with, and that the trade union formed thereby is entitled to the registration under section 6, then then it can be registered the trade union in the manner that is provided in section 8, and the amalgamation shall have effect from the date of such registration. Effects of change of name and of amalgamation. Subsection 1. The change in the name of a registered trade union shall not affect any rights or obligations of the trade union, or render defective any legal proceedings by or against the trade union, and any legal proceeding which might have been continued or commenced by or against it by its formal name may be continued or commenced by or against it by its new name. Subsection 2. An amalgamation of two or more registered trade unions shall not prejudice any right of any of such trade unions or any right of a creditor of any of them. Section 27 deals with the dissolution. So, when a registered trade union is dissolved, notice of this dissolution is to be signed by seven members and by the secretary of the trade union, and shall within 14 days of the dissolution it should be sent to the registrar and shall be registered by him if he is satisfied that the dissolution has been effected in accordance with the rules of the trade union, and the dissolution shall have effect from the date of such registration. Subsection 2. Where the dissolution of a registered trade union has been registered and the rules of the trade union do not provide for the distribution of funds of the trade union on dissolution, the registrar shall divide the funds amongst the member in such manner as may be prescribed. That's all. Thank you.